Welcome to Practical Law. I'm your host, family law attorney Henry Garnvine. I'm also pleased to say that Practical Law is now being co-sponsored by the Oakland County Bar Association. The bane of all attorneys is being sued by a client or former client. Legal malpractice is an evil that faces many attorneys, especially in certain areas of law. Today we're going to be discussing this issue with my guests who specialize in this area, Patrick Philbin and Theo Nitty. Welcome to Practical Law. First of all, why don't we start with you, Patrick, and why don't you tell us a little about your background and areas of expertise?
Sure. I'm a partner at the Plunkett Cooney Law Firm in their Bloomfield Hills office. I've been an attorney for 20 years, most of those years dedicated to the protection and defense of fiduciaries, who are individuals that have a legal duty to act for the benefit of others. This would include attorneys, accountants, real estate agents, individuals who serve on boards of directors as directors or as corporate officers. So whenever fiduciaries need assistance, we're there to lend a hand.
Theo Nitty, why don't you tell us about your background and your area of expertise?
Sure. Well, I'm a recovering lawyer, and like Patrick, I used to defend lawyers in malpractice actions. And then about 7 years ago, I went in the insurance industry, and I now work for a company called Oswald Companies. And what I do is specialize in the placement of lawyers' professional liability policies, not just the brokerage and the placement, but also helping my law firm clients manage their claims should they arise.
Patrick, do you see a rise in legal malpractice?
There has been a rise in legal malpractice claims. Last year, 2011, there was an across-the-board increase of about 10% of claims. It's across the country and across all claims. It's starting to level off this year in terms of the numbers that have been seen for 2012, but the overall volume of cases is actually quite high.
Do you have any, is it partly because of the economy and that attorneys are struggling and taking cases that they shouldn't be taking, perhaps, as part of the reason?
I think those are a couple of reasons there. I think, first of all, there's more lawyers now than there have been in the past. And with more lawyers out there, you've got more lawyers competing for a finite pool of business. We've got lawyers that might be willing now to take on cases that they might not have taken on in the past, or hold on cases that they might have referred to other attorneys in better times. They're handling cases outside of their fields of expertise, if they have a field of expertise. They're taking care of cases and clients that are outside of their comfort zone, and that becomes problematic. And the downturn in the economy, I think, has contributed to this as well. You start seeing, again, attorneys holding on to files that they haven't held on to in the past. You're seeing an increased filing of bankruptcy matters. And for some reason or another, and perhaps Theo knows this, there's just a lot of legal malpractice cases that come out of bankruptcy filings. Also, the downturn in the real estate market in 2008, 2009, there's a lot of investors that had a lot of money invested in real estate. And when those deals went south, you had a situation where the investors are looking to recoup their losses. And they'll look to anyone that touched the deal, including attorneys that were involved in that deal too. So the economy has, in that fashion, affected the increase in legal malpractice claims.
Theo, you know, law covers a broad spectrum and a lot of lawyers specialize. Are there certain specialties that seem to get hit more than others?
There are, and the insurance companies are very in tune to which specialties seem to draw out the claims. And consequently, lawyers practicing in those areas will pay a little bit more for their insurance. The traditional high-risk areas tend to be plaintiff work because you have more litigious clients to begin with. Intellectual property is one that gets mentioned a lot. The frequency in IP matters tends to be lower, but the severity is high. Also, anything involving closely held corporations because of the issues over who exactly is the attorney representing. And I hate to say it, but also family law tends to be there as well. Recently, as Patrick was saying, with the downturn in the economy, real estate, particularly commercial real estate, has become really the the area with hair on it that the insurance companies are watching closely, and hopefully most of that is behind us, but we still do see the claims pop up where the client is looking at the attorney when the deal goes south and looking at the attorney actually as a guarantor for the losses.
Wasn't that where we are? Yeah.
Hopefully not.
Theo, what are some steps that attorneys should take to avoid being sued or to avoid being committing legal malpractice, for lack of a better word?
Well, there are a lot of things that lawyers can do. Something that gets brought up a lot, you know, when the ABA does their studies and when clients who sue their lawyers are asked why they sue their lawyer, the thing that comes up a lot is communication. And that's a broad topic in and of itself. You know, the lawyer didn't get back to me, I didn't know how to reach the lawyer. So that gets mentioned a lot. That's one area. Another thing is just client education, things like having an engagement letter that's a good engagement letter that provides a roadmap for the client. Another thing is not nickel and diming a client on fees. You create an adversarial relationship with a client, and that kind of sets the tone for the whole representation.
Let's address some of those points. Patrick, what about failure to communicate? And I think a case you and I were involved in not too long ago, I think that was one of the key issues, really.
You know, it's a key issue in a lot of cases. It's one of, I think, what Theo and I might call one of the 7 deadly sins. A lot of legal malpractice cases come out of the failure to communicate between attorney and client. Something as simple as the failure to return a phone call. You know, at my firm, you've got to return a phone call within 24 hours. That's in the Plunkett-Cooney manual. It's something that we have to do. If I get a call from a client in the morning, I should be on the phone with that individual by the end of the day, certainly within 24 hours. Another thing that's important to do is to open up and maintain a line of communication between attorney and client. I met with a new client just yesterday, and one of the questions I asked him was, how do you want to communicate? Should we do it by email? You want to do it by phone? You want to do it by fax? I don't care how you want to communicate, but let's establish early on how it is we're going to communicate, so I know how to get in touch with you and you know how to get in touch with me. You can talk through the rest of the problems from that point on, but you're never going to resolve a claim, and you're never going to be able to satisfy the needs of the client unless you have an open line, an open channel of communication.
Theo, what about the issue of written engagement letters?
The engagement letters are kind of an issue near and dear to my heart. Based on my experience with an awful lot of claims, not my own, but handling those for my clients, I think the engagement letter is something that gets overlooked a lot, but is probably the lawyer's best defense, both in avoiding the legal malpractice claim and then defending it if it actually does happen. You know, too often I see engagement letters coming from lawyers that are 1.5 pages. It focuses on what the client needs to pay them on an hourly basis. The engagement letter needs to be a lot more than that. It needs to identify, first and foremost, what the lawyer is going to be doing for the client, and maybe even more importantly, what the lawyer is not going to be doing for the client. We call it defining the scope of the engagement. So for example, if you're an intellectual property lawyer, you might say something like, we are going to procure the patent for you in the United States. We are not going to be procuring the patent for you in Canada or Mexico or something like that. And a good engagement letter provides the client with a roadmap so they know what to expect and what their responsibilities are going to be, because you know, any litigator that's gone through discovery with a client that doesn't get them the documents they need knows that can be fairly tough. You know, for a client, just knowing what they have to pay the lawyer on an hourly basis is like going for a ride in a New York taxi cab with the windows all blacked out. You don't know where you are, you don't know where you're going, but you can see the meter constantly clicking up, and that's just a bad basis for a lawyer-client relationship.
How do you get around that? Because, you know, it's like, I think we're talking about two things. One, you got a retention letter, and another one is a letter really explaining more of a roadmap, which is what I do. I have 2 letters that go out at the beginning of a case, defense standpoint. Before the break, Theo, we were talking about really the importance of a good engagement letter in setting the roadmap. So why don't we continue a little bit along that vein?
Sure, sure. Yeah, the engagement letter needs to let the client know what their responsibilities are. You know, a duty of candor and honesty, providing documents in a timely fashion, things like that. And then, you know, and all this comes before you mention fees. You need to let them know who's going to be working on their matter. You know, it'll be this partner, but you can also reach this partner and this associate. They'll need to know a little bit about the process. You know, most lawyers at some point come in contact with somebody that's a neophyte to the litigation process or the transaction process or whatever it is, and they need to be educated a little bit on what that process is like so that they're frankly not scared by it.
Patrick, let's talk about the issue of conflicts of interest. And what do you mean by that?
Well, conflict of interest is another big one. I think Theo would tell you see an awful lot of conflict of interest issues that are talked about in legal malpractice cases. Attorneys, in fact all fiduciaries, are required to act in the best interest of their clients, and that means the professional judgment that you're employing on behalf of your client can't be clouded by a conflict of interest. It couldn't be that my interests come ahead of the client's, or that the interests of a third party cloud my judgment relative to what I'm doing for the client.